Hello, welcome everybody. To those that joined us on Tuesday, welcome back, and we hope you found that session useful. To those joining us for the first time today, welcome. My name is Samantha Reddy, and I'm a content manager at LexisNexis. This new initiative, named the LexisNexis Agility Matters Express webinar, is designed to keep customers updated in a flash with the critical content they need right now. Today's session is part 2 and we'll be dealing with civil trials and ADR. We are so thankful to Advocate Monovic for giving us his time and his efforts to assist pupils prepare for their admission exams. This is a reminder that this is just a half-hour session, and the recording of this session will be made available within a few days. Thank you, Chris. Over to you.
Thank you. Thank you. Good morning, everyone, and welcome. We don't have much time, so I'm going to speed things up a bit, if you don't mind. Could I go to the first tile, please? The second, I mean, actually, sorry. You will notice from the syllabus that you have for this particular subject that there are 4 separate subjects within this one paper. They are trials, appeals, alternative dispute resolution, and the law of evidence. I would suggest that you study each of them separately as best you can, using the syllabus as a checklist of the topics that you should get under control. I would recommend for civil procedure the book by Harams. My book, Litigation Skills for South African Lawyers, covers the litigation process from the first meeting with a client to the final appeal. So that could be used as well. It also has a specific chapter, chapter 3, on alternative dispute resolution. Then for the law of evidence, there is no better book than Zeffert and Paisley's South African Law of Evidence, the 3rd edition. You should also study the 2 past papers, that is for the years, sorry, those are for the years 21 and 22. Those will give you a good idea what the paper is likely to contain. Also, on the topics that are not covered in those 2 exam papers, you should anticipate questions on particular topics. It would be useful if you could work with a friend or a colleague to brainstorm on questions that might be expected on particular topics. Could I have the next tile, please? Okay, now I've taken these past papers and I've identified certain topics that came up more than once. The first one is alternative dispute resolution, and I'll come back to that one. The question which they always ask or appear to be interested in is whether you should institute action or motion proceedings. Then there's High Court Rule number 18 about pleadings generally. I'll talk about that one in a minute. Discovery, appeals, law of evidence, and heads of argument have also appeared in the past papers. So please do yourself a favor and be fully prepared on those topics, going back again to the lists of topics within the published syllabus. Next tile, please. Here are some questions that have been asked about alternative dispute resolution in these 2 papers under discussion. The first one is the differences between litigation, arbitration, mediation, and the advantages, disadvantages of each, and whether appeals are possible. I can tell you in advance that those subjects are covered in detail in my book in chapter 3, and in particular, there's a table at page 67 which would answer the questions in that first bullet point completely. A question which has been asked is this one: similarities between litigation and arbitration. Now, the answer is, of course, that in arbitration, you appoint the arbitrator and have to pay for him or her, and you have to hire the venue. And then, of course, the two procedures are usually conducted as in very similar fashion, with oral evidence, cross-examination, argument, and so on. Although the differences could be more time-saving and cost-saving if you were to run the arbitration in a cheaper fashion. Anyway, Rule 41A has come up more than once in the exam papers. Rule 41A is the one which requires parties in certain cases to include an invitation to mediation. That is particularly the case in divorce matters and matters arising out of the Children's Act. You should read much wider than chapter 3 of my book in order to be fully prepared on this particular topic. Could I have the next tile, please? We now get to High Court Rule 18. This is the rule that sets out the requirements for pleadings in great detail. Questions which have been asked in the past papers include these: who must sign a combined summons? What must every pleading contain? What does the rule require with regard to the quantum of a damages claim? What is meant by the material facts? What, if anything, can be claimed under further or alternative relief? I think you can do no better than to read chapter 5 of my book. I deal with Rule 18 in some detail there. And then Amler's Precedents of Pleadings has what I regard as the best summary of the relevant principles in pages 1 to 12. That is part A of Amler's book, written by Justice Harms, who used to be the Chief Justice, or Deputy Chief Justice, I should say, of the Supreme Court of Appeal. Thank you. Could I have the next tile, please? The question which always comes up, or has come up more than once in these exams, is what the difference is between an action and an application. Now, guys, I know the answer, of course. I wouldn't be sitting here if I didn't, but it's not my job to tell you the answer. It's my job to tell you where you can find the answer, and to try to persuade you to go and look for it yourself. You'll find greater satisfaction and learn more by looking for the answer yourself and finding it. You will remember the answer better that way, and you will remember the process that you adopted to find that answer, and you will learn to adopt that same process when you need to find out something else. In any event, the answer is given at page 167 of my book. You will find the answer in the book by Harms, Civil Practice in the Superior Courts of South Africa. You will find it in the prescribed readings that you have to do in the syllabus. And if you want to go as far as this, you will find the answers in the law reports. Questions which follow from this distinction are the following. When would an application be appropriate? There are different, shall I say, circumstances where an application would be appropriate, and there are others where it would not be appropriate. You need to study the chapter on applications in Harms's book very carefully to determine what the answers to those questions would be. And the next item is this: are there cases where an application is the prescribed procedure? And of course, you have to think of examples where that should be the case. Off the cuff, I can think that an application under Rule 57 has a prescribed procedure, that is to have someone placed under a curatorship. Another example would be a review under, Rule 54, of the High Court rules. There, the procedure prescribed is an application. There are other cases where motion proceedings are inappropriate. Consider, for example, the following. Would you, as counsel or attorney for a party, institute motion proceedings, that is, notice of motion and affidavits, in these cases? Breach of contract, an application for an interdict, a divorce, a review. You have to motivate your answers. Let's take a breach of contract case. Do you think that it is likely that there would be a dispute between the parties about the facts of the case? Do you think that maybe in a breach of contract case, there will be a damages claim? Do you think that maybe the courts have said repeatedly that application proceedings, motion proceedings, are inappropriate for damages actions, even if it's a claim for defamation? Have a good look at that. The divorce question is quite easy. Can you do a divorce by way of application? The short answer is no. I don't think anyone would ever have tried that. But of course, within a divorce action, you could have interlocutory applications. There's an application under Rule 43 for interim custody, maintenance, and that kind of thing. There could be, within a divorce action, an application to compel discovery, and so on. So do not completely throw out motion proceedings in cases where there is an action. I'll come back to something important not covered in this tile in a moment. The next item on this list, on this tile, is what the test is, should there be a dispute of facts which cannot be resolved on the affidavits in motion proceedings. You should draw a distinction between an application for an interim interdict, for example, and an application for a final order or final relief. There is a big distinction. You will know that the case of, what is it called again? Let me look at my notes. Anyway, there's a decision that says where final relief is claimed, the matter will be judged on the allegations in the founding affidavit, which are not disputed, together with the allegations made by the respondent in their affidavits. So be aware of the fact that you need to be able to answer a question of that nature. When it comes to motion proceedings, there are many different kinds. You could have an application for substituted service or edict on citation. You could have an application for an arrest under the rules if that was still applied. You could have an application to join parties. Those are interlocutory procedural applications. Then you can have applications for interdicts, which become a lot more involved. You could have applications for a Mariva injunction or an Anton Pillar order. Those have to be brought on application because they are always brought ex parte, that is to say, without notice to the respondent. This is a big topic, applications, and you are guaranteed, guys, to have a few questions on applications in this exam. Can I have the next tile, please? Another subject that always comes up too is appeals. And of course, you have about 4 kinds of appeals here. You've got appeals from the magistrate court, and there you will have to consult a book like Jones and Buckle, Practice and Procedure in the Magistrate's Court, or any other book. LexisNexis provides a book as well on the procedure, time limits, and the requirements of leave to appeal in civil cases, civil trials in the magistrate's court. Then you have appeals. This is the converse of the appeals from the magistrate's court, appeals to the High Court. Those are regulated by Rule 49. Those appeals don't only arrive from the magistrate's court, they could also arrive from a military court. Then we get to appeals from the High Court. And there are, of course, two kinds. There's the first, which goes to a full bench of the same court or the same division. And then there are appeals that go from the High Court to the Supreme Court of Appeal. In very, very exceptional cases, will an appeal go from the High Court directly to the Constitutional Court. In any event, you should know what the requirements are for an application for leave to appeal, when that application may be made. I may answer that one quickly. You can make that application immediately in open court when the judgment is given, or you can make it later by way of a formal application, setting out which parts of the judgment are appealed against and the grounds of appeal. That is by way of an interlocutory application. Of course, the procedure I've now more or less covered. Appeals to the Constitutional Court require, in, I think, almost all cases, leave to appeal. I think there are cases where leave to appeal may not be necessary. For example, the certification of certain matters. I think that goes beyond the ambit of your subject. In any event, in appeals, heads of argument are required in all the courts where appeals are now heard. And you should be aware of those requirements, especially with regard to time limits, content, what documents ought to be attached by way of a schedule, and so on. I deal with the subject in chapter 25 of my book, and you will find a great deal of detail with a lot of footnotes and case law in Harms's book, which I referred to earlier. Can I have the next tile, please? I think you should also anticipate questions which, from my experience of past bar exams, not just the last two, were always in the exam papers. The first one is the question of discovery. This particular question was in one of these two past papers, and that is what you would do if a document has not been discovered by a party. In the question which was asked in the past paper, they postulated a situation where, while the plaintiff is conducting its trial or its case, calling witnesses, people suddenly realized that there was a vital document which had not been discovered by the plaintiff. Now the examiner asks, what would you do if you're acting for the plaintiff? And then the examiner asks another question and says, what would you do if you were acting for the defendant? Now this will require a discussion of the rule and what happens if there has been non-compliance with a rule. And I should think if you're acting for the plaintiff, you would seek permission from your opponent to use the document subject to an adjournment and costs. Or if your opponent says no, you may have to apply to the judge presiding for the matter to stand down, for a formal application to be made by way of a notice of motion and affidavit for the document to be used. And again, I'm sure you would have to tender a postponement to your opponent together with the wasted costs of the adjournment. Now, if you're acting for the defendant, you would consider each of these stages as they come up. If your opponent should come up and says, sorry, I didn't discover this document, I need it. Would you allow me to use it? Do you need a postponement? I'll pay the costs if I have to. You need to consider the interests of your client when making that decision. And you may well find that you have not been prejudiced or that you do not need a postponement. and that the matter could proceed with a short period of stand down for you to allow to consult with your witnesses. If the matter comes to an application, and if you should think that there has been underhanded conduct on the part of the plaintiff, dishonesty or something of that nature, then you may want to say to your opponent, no, we're going to oppose this application. And then you'll have to file an opposing affidavit in due course and deal in particular in that affidavit with questions of prejudice and wasted costs. If the prejudice is severe, the judge might well disallow the use of that document. So you would have to use that. Anyway, I've now given you a long explanation to give you an answer to a question which I think in the exam merited 10 marks out of 50. Anyway, let's go to the next item, which is the law of evidence. There's a huge list of matters here, which range from the difference between oral evidence and documentary evidence, real evidence and documentary evidence, the exceptions to a number of items, hearsay evidence, parole evidence, what else? Opinion evidence, similar fact evidence, and so on. Each of those is discussed and explained in Zephyr's book. Guys, you are going to have to study that. There's a short section in my book on that subject. I can't remember which chapter, but it's there. It's your job to find it, not my job to spoon feed you. It's under the subject matter of objections in a chapter in my book. I would suggest with regard to the law of evidence that you should work in groups. Two heads are usually better than one when it comes to discussing fine points of law and difficult issues arising from your syllabus. As a matter of interest, I wrote the attorney's admission exam in 1975. Yes, I'm old and tired. I didn't have much experience of a number of topics within the syllabus for that examination. But what I did was that I found a friend in another firm who had literally no experience in two areas where I had a good deal of experience. My experience was in civil trials and criminal procedure. My friend's expertise was in the drafting of wills, estate administration of estates, drafting of contracts, and, if I remember correctly, accounting. So what we did was we arranged topics for discussion a day ahead. We would meet at my house. He would lecture me on the subject that he had studied or prepared, and I would do the same with the subject I had prepared on. And that way, we went through the syllabus, the whole syllabus, I think, in 10 or 15 evenings. And I'm happy to say we both passed the exam, and I immediately forgot anything I ever knew about bookkeeping. But anyway, that's a method that you can use for your preparation for this exam, which I promise you is a big exam and probably the most difficult of the 5 papers that you have to write. Thank you. Can I have the next tile? Okay, this is my moment to say thank you very much for listening to me, for humoring me and giving me the opportunity to poison your minds. Thank you, Samantha.
Thank you, Chris. Just waiting for my video to start. It's not working for now. Thank you, Chris. It was informative and amusing. Thank you for your personal anecdotes. Okay, before we sign off, I want to mention that LexisNexis has a number of the prescribed print works for the bar exams and also offers discounts on our online platform, Lexis Library. For pupils, please, when you complete the on-screen poll, we need this information to ensure LexisNexis resources are available to support you in your exam preparation. I hope you found this quick update helpful. Please remember, we designed this webinar to help you with your exam preparation and give you guidance on common focus areas. It should not be taken that everything covered here will be covered in your exam, or that everything covered are the only areas that will be included. Also note that today's recording will be made available to you within a few days. Thank you so much for joining us, and we wish you all the very best with your exams. Thank you again, Chris.
Thank you.